Good evening. We, the unwilling, led by the unknowing, are doing the impossible for the ungrateful. We have done so much for so long with so little. We are now qualified to do anything with nothing.
I'm ordering you as a condition of your bond not to participate in this kind of behavior. Good morning, Mr. Godfrey. Sir, you are charged with two cases. You're charged with evading arrest or detention. You're also charged with failure to identify oneself, giving fictitious information. On the evading, you are facing up to a year in jail, and on your other case, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 6, 2025, officers responded to an assault in progress in Harris County, Texas, and met with the complainant, who reported a young black male involved in an assault. The complainant identified the defendant, and the officers attempted to detain the defendant when the defendant fled when he saw the police. The officer pursued the defendant on foot, and the defendant was located by the officer after approximately 100 yards after attempting to enter another apartment. The officer instructed the defendant to surrender. The defendant then jumped down from a second-story stairwell in an attempt to flee, and the defendant was then apprehended by the officer while the defendant continued to resist. Once detained, the officer attempted to obtain the defendant's date of birth and name. The defendant would not provide a date of birth and give a false name. After multiple attempts, the defendant provided the requested information.
Okay. So was he the one that they were actively investigating?
Yes, he was identified by the complainant as being involved in an assault, and they tried to investigate and detain him for that assault.
What happened with that?
Let me see if there's any further information about that. So in regard to the original assault, it was determined that no assault occurred, but it was after further investigation.
Sure. Okay. Mr. Godfrey, I'm going to find that there's probable cause to go forward with both of your cases. How old are you, sir?
17.
What do you do for a living?
I'm searching for a job right now. I'm going to work at the warehouse.
Did you graduate from high school?
No, sir.
You need to.
Yes, sir.
You need to get back into high school.
So that's what I'm working on right now. We're working on putting me back in school. I'm getting back on track.
Who are you here with today?
My aunt, she's parking.
She's what?
She's parking. Like she's paying for parking right now.
Is that Aunt? Are you Aunt?
No, sir. She's downstairs. She ain't make it upstairs. I came up here. She's looking
I'm
for
gonna give you a
parking
lawyer.
spot.
I'm gonna give you a lawyer today. I want you to get back in school, and I'm making that a condition of your bond. You have to graduate from high school. You will be in this life. Education is where it starts. If you don't have an education, at the minimum, a high school diploma, you're going to be making pennies to when everybody else is making dollars. Do you understand?
Yes, sir.
So I'll give you a lawyer today. I'm going to have you talk to the lawyer. We're going to figure out how to get you back into school. I'm going to give you 2 to 3 weeks. And when you come back, I want you to show me that you've either enrolled into high school or you started working on your GED. If you've done nothing, it's not going to go well for you. No smoking weed. I'm going to test you. I want to make sure that you're not using as well. Do you understand? I'm sending you for a drug test now because I want to make sure that you're not using. Is that Aunt? No? Okay. So can you appoint him a lawyer, please? All right. I'm going to have you sign a receipt with Victoria. I'm going to have you get with pretrial. And I'm going to have you go take a test. I'm going to have you come back. And then I'm going to have a lawyer when you come back. All right? Okay. Okay. All right. I guess let's do this. Ms. Esquivel, you are charged with violation of a bond or protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 8th, 2025, in Harris County, Texas, the officers were conducting surveillance on the defendant who had active warrants out of the 178th as part of a fugitive task force when they observed the defendant's vehicle parked at a location where the defendant was prohibited from going due to an active protection order. The officers then observed the vehicle drive away, driven by the complainant of the defendant's open case in the 178th. The officers then observed the vehicle to have an expired registration and initiated a traffic stop. The officer then found the defendant hiding in the back seat. Both the complainant and the defendant acknowledged that the defendant was prohibited from the residence.
So she was at the
She was at
residence.
the complainant's residence, yes.
Was she with the complaining witness
complainant.
as well?
Yes. They
Okay,
were
so
together.
how bad are we talking the ag assault? Do you mind telling me about that?
I'll tell you about the aggravated assault, Your Honor. So in the aggravated assault, the officers were dispatched to a disturbance and they met with the complainant who stated he was involved in a verbal altercation at a bar earlier in the morning. And then once the complainant arrived home, he was locked out of his house and had to force the door open. And that started another disturbance with the defendant. The defendant threw several items at the complainant, and the defendant began to strike the complainant on the back of his neck several times with their hands. And the officer observed the complainant to have red scratch marks on his neck. Further, the defendant retrieved a black compact handgun and pointed it at the complainant and racked the slide, thereby placing the complainant in fear for his life.
Okay. Ms. Esquivel, I'm going to find that there's probable cause to go forward with your case. I want you to understand something very, very clear. The Texas Constitution does not allow me but in extremely limited circumstances to hold someone at bond. Zero bond. This is that situation. I'm going to put a protective order naming this person as a protected individual. If you so much as do anything to violate any of these conditions, I can have a hearing to hold you at no bond. And I will do it in a heartbeat to protect every person in my county. Do you understand? You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. No weapons, no contact with the complaining witness, and no going. I'm assuming, is it a he, she? Well, it doesn't matter. You're not to have any contact. Don't go anywhere where this person lives, works, anything. Do you understand? I don't want to talk about the case, but
President, I'm a little
Oh.
confused.
who's your lawyer?
Robert Valles, and he's on my case. He was supposed to be here this morning. I'm a little confused.
Do you know, has Bo said he's going to show? We had no idea that you have a lawyer. Okay, so let's do this. What I can do is I can have you take a seat. We'll wait for him to get here. But regardless, I'm putting these conditions on your bond. I've found that probable cause exists to go forward with your case. The only thing I'm telling you now, don't violate any of these conditions because there are severe consequences.
Yes, Your Honor.
We'll go through it again when your lawyer gets here, but just don't leave until he gets here, okay?
Your Honor.
For now, I'm gonna have you sign a reset with Victoria. We'll have you get signed for your conditions. Just take a seat momentarily. Well, once he gets here, then we'll go through it.
Yes, Your Honor.
Okay.
Good morning, Judge. Generally 2 minutes. Oh, thank you. Of course.
Good morning, sir. Mr. Lauderdale, you're charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a gas station in Harris County, Texas, in regard to an assault in progress. The officer made contact with the complainant. The complainant stated the defendant had damaged his vehicle, that the complainant had parked his vehicle at the gas station by the front doors. As the complainant was in the store, he observed the defendant standing by the complainant's motor vehicle with a large rock concrete piece over his head, and the defendant threw the rock, breaking the front of the complainant's windshield, causing $1,000 in damages. The officer observed the large concrete rock sitting on the hood of the complainant's vehicle, and the defendant stated he was upset but did not elaborate.
Mr. Lauderdale, I'm going to find that there's probable cause to go forward with your case. You missed court, and I issued a warrant for your arrest. I'm going to recall that warrant now, but if you miss court again, it's not going to go well. Do you understand? Do you need a lawyer? Can I give you a lawyer? I need you to talk to me. Okay. I don't want you to pick up any new cases. I want you to be nice. Do not go back to this McDonald's. Do you understand? Do not go back to this McDonald's.
Your Honor, it's a gas station.
Oh, where is it?
Let's see.
I thought you said it was a
A
McDonald's.
gas station on Belfort Street.
Okay, please don't go back to this gas station. Do not pick up any new cases. Do not be a danger to my public. Do you understand? Okay, so if you please provide him a lawyer. All right, I'm gonna have you take a seat in the jury box while I find you a lawyer, okay? Please, yeah. Sit it. Okay, who do we have here?
Bill, Austin.
Good morning, Mr. Austin. Oh, I guess it's Mr. Rubio, not Mr. Austin, right? Sir, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 13 days in jail with credit for the 21 days that you've done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this. You can't change this. It's going to go on your record. From now on, you're facing a minimum of 30 days in jail. Do you understand?
Yes.
Is this what you want to do?
Yes.
How do you plead to the offense of criminal trespass? Guilty or not guilty?
Not guilty. Wait, not guilty.
Are you not guilty of this offense?
Yes. Yeah, not guilty.
Mr. Rubio, remember when we spoke?
Yeah, it's not guilty. Yeah.
Okay, I can't accept this if you're saying that you're not guilty. You know, this is what we do here is if you're guilty of this offense, then you plead guilty or whatnot. But if you're not guilty, then we can't do this.
Okay.
Remember what we talked about?
Yeah.
If you're not guilty, then you're gonna say not guilty, but if you're guilty,
What
then you can
hap-
take the plea.
what happened in
Okay.
this case?
So in this case, there was suspicious individual roaming the garage and the witness, the Metro supervisor stated she received multiple reports about an individual looking in the car windows and walking away when seen. The officer made contact with the defendant. The defendant was previously issued trespass warnings of the same property on August 14th, 2024 and August 27th, 2024. The defendant stated he had returned to Park and Ride because he has nowhere else to go.
So where was this location exactly?
A Park and Ride at 1030 West Grand Parkway.
Did you understand what they
Yes.
said?
Yes.
Based on what he said, are you guilty or not guilty?
Not guilty.
Okay. Can I talk?
Email?
Yeah, I will.
Okay.
Okay, Mr. Rubio. We're gonna go back. I'm gonna talk to you, okay?
Okay.
Okay.
Send it like,
Yeah.
okay. Ms. Young, coming up.
Good evening, morning.
Don't look at his computer.
Sorry, I was trying to get the time from him.
How's jail?
Evening. Sorry,
How's jail? Shh.
treating us beautiful.
You know, we can't get you to come. We can't get you to appear.
Well, what happened was this time.
No, but there's always an excuse. It's really easy to just pick up a phone and call Josh. How hard is that? You know, that's all we literally ask you to do is remain in contact with your lawyer. That's all you got to do.
Yes, sir.
We've repeatedly tried 4 different times. Your lawyer's asking me to let you out to get in this program, but I know if I let you out, you're just gonna
No, sir.
take off.
I'll do the program. That's not the problem, sir. Honestly, with the phone situation, that's how he has a whole different number since last time I came. I don't even have that number anymore. And with the transportation part, I don't have a car. So the way I move around is either using the bus or my feet, sir. And last time that I did come, I came on my own. No one told me to come. No one called me. I knew I ended up
don't
missing it and I came.
Unless you're wearing orange. That's the only time we see you.
No,
You
sir,
don't-
I turned myself in. I came in myself after I missed my court date and I came in by myself.
When?
I can't give you a date, but if you look on there, I sat here and waited till everybody even left.
Guys, did she turn herself in or she got arrested? Can you tell? If you turn yourself in,
I
that
came
would
to
make me
court.
very happy. But if you just got arrested and that's why we have you,
Sir. No, sir, I came to court.
Young, she's on the jail doc. Last page, I think. Fool me once, shame on you. Fool me twice, shame on me.
I'm not trying to fool anybody, sir. Are you able to look that up for me?
So, yeah.
Okay.
The date
Is it on there? Because it was like 2 days, yeah, like it was 2 days after my court date, I came. No one called me, I just knew I missed it and I didn't have a ride, but I made sure to get up there because that's how I got my date reset the first time.
Looks like the booking date was the 12th, Judge, but I don't know. That's all I can see from my side.
That's when I came to talk. I've been here since.
Where did you come to?
Sir?
Where did you go to? Did you turn yourself in the jail? Is that what you're saying?
Sir, I went to the Franklin Street, if I'm not mistaken, Franklin, 1200 Franklin, where all the court is at. Where I was supposed to go the first time. 1200 Franklin, if I'm not mistaken.
It was on Sunday, though. Was it on over the weekend?
Honestly, I don't even remember what day. Oh, this time? Yes, sir, I can't.
Let me, you know what we could do is we could do this, is that if we're gonna do this, you know how we do that release that we release to people?
Right.
Something like that. So we know that she gets to the P180 place. Where is it? Where did they do the interview? Do you know?
I guess because it's not like an inpatient facility, would it be different if it's?
Where does it happen? Do you know? Do you know where the interview happens, Josh?
I'm not sure like physically where it is, the P180. I'm checking the state though. Because I guess she wouldn't be released to that program. She'd just be released and have to.
Do you have a date already for it? Do you have a date for it?
There's like a way to book it online, but they said that you have to send a contract to PTI, P180 contract. So, which I think is what we have now. So I think we should be able to schedule it now.
Okay, so let's do this. Schedule it, get a date, and then I'll put a GPS monitor on her prior to release. I'm not going to do this again. You ever take off on me again, I swear on everything that's holy, that'll be the 5th time. Do you understand? So I'm not giving you a PR bond now to just wait, get a date. We'll set it for like the day before, and then we'll give her a PR bond with a GPS prior to release. The instruction is she goes directly to get the interview done, and then we'll go from there. But I'm not going to continue to play this game.
But I'm not playing the game, sir. It's been cold. Like, what do you expect? It's been 20 degrees, sir. 20 degrees. You know how hard that is to actually stay.
Your finger's so frozen that you can't make a phone call?
Sir, I just got the phone. That's what I'm telling you.
If you need resources, we can give it to you. If you need a phone, if you need a tablet, if you need food, we have resources to give you. But you take off, you don't call, you don't come to court. So what are we supposed to think? And we just can't keep, I've got 4 different times. I can't continue to do the same thing.
We'll get the schedule.
All right. Do it and we'll see. Okay.
He's in the box.
All right. Come up, Mr. Lauderdale.
There's some cognitive issues.
I'm just asking him to be nice. You know? Mr. Lauderdale. Be nice. It's not hard. Self-control. I've given you a lawyer. You have to stay in contact with him. If he tells me that he cannot get a hold of you, I'm going to issue a warrant for your arrest. Do you understand? Okay. Do you have any questions? All right. Do you have a cell phone?
He gave me a phone number I can reach him on. His mother's.
Okay. Do you want a cell phone? We have services that we can give you so that you can get your own cell phone. Do you want one? Okay. Do you mind giving him, we're going to give you paperwork, but you have to do the work, but I'm going to give you the resources to be able to get a phone. If you need anything else, come back, talk to us, and we can try to give you whatever you need. The worst thing that can happen is that you don't come back. Okay? Perhaps we should do not waived. I don't know. It's up to you, whatever you think is appropriate.
Yes,
Okay?
sir.
All right. Good luck.
Thank you, Judge.
Josh. Morning, Mr. Garcia. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 9th, 2025, officers were dispatched to a disturbance with a weapon at a Boost Mobile business in Harris County, Texas. The officers were advised that 2 suspects were trying to rob the store, one with a handgun and in a wheelchair. The officer observed the male matching the description inside the business, and the defendant turned as if he was going to leave. The officer asked the defendant if he had any weapons on him, and the defendant stated he did not have any weapons and that he was confused as to what was going on. The defendant agreed to the officer patting him down for weapons and immediately began reaching into his pockets, claiming he was going to retrieve his wallet. The officer observed the defendant to have an unholstered black handgun on the right side waistband tucked between his shorts, and the defendant claimed the handgun was his sister's, was borrowed for safety, and the holster was in his sister's car.
So you said they were robbing the place and
He was reported to be involved in a robbery, and that's what the officer was.
they charged?
They charged him with, no, just the possession of PCS and then the unlawful carry.
Mr. Garcia, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using illegal drugs, any kind of alcohol, I will put you in jail. No more PR bonds. As it stands now, you're on felony probation. You've now picked up a case with us and you have a felony possession case. Is there a co-defendant in this case?
Yes, Your Honor, there actually, no, Your Honor, there's not.
You said
They allegedly had 2 suspects, but the officer only made contact with the one defendant.
you're not to be in possession of any weapons, no alcohol, no drugs. Do you understand?
Yes, yes, sir.
Tell me, do you need a lawyer appointed to you today?
Yes. I'm getting one, but not right now.
I can
So yeah.
now if you want.
Okay.
Don't pick up any new cases. Don't be a danger to my community, Mr. Garcia, because I'm going to tell you now, I'm going to protect
I was
my
buying a phone.
Stop. Don't say anything. Just, I want you to know that I'm going to protect my community at all costs. Do you understand?
Yes, sir.
I don't know what happened. I wasn't there. We got to wait for the evidence to come in. That's going to show us whose side is correct. I don't know. We'll get there. But just while you're out there in the free world, make the right moves. Because if I see you making wrong moves, I have only one place for you. Do you understand? Can you reach out to the MAC for Mr. Garcia, please? All right, so for now, I'm going to have you sign a reset with Victoria. We'll have you get with Ms. Smith for your bond conditions, and then I'll have you take a seat in the jury box. Please. Hi, Casey. Happy Friday. How are you?
Any big plans this weekend?
No, not really. Just kind of hang out with my folks, you know. Yeah. You? Anything good?
No, I have a friend's 35th birthday party tonight, but
That'll be fun.
yeah,
Yeah.
mob themed, so.
Oh, awesome. Are y'all going to like a special place for it?
No, their house.
You were Miss Tijerina.
Yes, sir.
Ma'am, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 11th, 2025, the officer observed the defendant's vehicle bearing an unreadable E-tag at the 6900 block of Spencer Highway. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The defendant stated she was aware the E-tag was unreadable as it was waterlogged from being so old, that the E-tag was expired as of November 2024, and that her license plates were at home but not yet on the motor vehicle. The officer confirmed the defendant was operating the motor vehicle with the wrong license plates and observed no proof of financial responsibility for the vehicle. The officer observed slurred speech, red glossy eyes, and a strong odor of an alcoholic beverage. The defendant stated she was coming from a local bar, had consumed a bucket of Michelob Ultra beers, and standard fields of writings were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and attempted a breath. The defendant attempted to provide a breath sample, but was unable to complete the test. A blood search warrant was signed and executed.
Did you say she did field sobriety test or no?
She did. Would you like me to read them again?
Yeah.
HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4.
Mr. Kitty, I'm going to find that there's enough probable cause to go forward with your case. Can you see if she has a valid license?
It's eligible, Your Honor.
Okay, I'm now placing a restriction on that license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. You're also not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming, I'm going to revoke your bond. I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
And Judge, we're fine with the random testing. She did already let me know of a scheduled trip that she has, so can we let pretrial know those dates?
You can go on your trip, but understand you're still not to use. You're going to get tested as soon as you get back. If you test positive, it's not going to go well for you. Do you understand? I
Yes,
don't
sir.
care where you are in this world. You're still under bond condition in this court, not to use. Don't get in trouble. Make wise decisions, because if you don't, there will be disastrous consequences. And while you're out there, if you're driving, you're not allowed to unless it has an interlock on it. Do you understand?
Yes, sir.
Okay. So yeah, let Ms. Smith know about the travel, so that way.
I don't want her to get
knows.
violated this.
So you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Casey, and she'll tell you when you have to come back to court. If she tells me that you've gone AWOL, she can't get a hold of you, I'm gonna revoke the bond. Do you understand, man?
Yes, sir.
All right. I'll have you sign a reset with Victoria. We'll have you get with Ms. Smith for your bond condition, and then you're free to go. Thanks, guys.
Thank you, Judge.
Have fun tonight. You are Porter Jackson. Mr. Jackson, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 10th, 2025, the officer observed the defendant's vehicle traveling east at the intersection of 2200 block of Spears Road and TC Jester with a defective license plate light. The traffic stop was initiated and the officer made contact with the defendant. The officer observed a strong odor of marijuana emitting from the vehicle, and a PC search was conducted. The officer located a green leafy substance believed to be marijuana based on training experience in the driver's side of the vehicle. The weight was approximately 1 ounce.
Was it?
It was on the driver's side.
All right, Mr. Jackson, I'm going to find that there's probable cause to go forward with your case. You run his license.
Not eligible, Your Honor.
If you don't have a license, you are not allowed to drive. Do you understand, Mr. Jackson? You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If you want to drive, go get a license, get liability insurance, come back to me, and I'll take this restriction off. But I'm going to tell you now, if I find that you drive, I'm going to sprout horns in the tail. Like, that's how upset I'm going to be. Do you understand? Tell me, did you want to apply for a court-appointed lawyer? Do you mind giving me, please? Okay. Tell me about yourself. What do you do these days, Mr. Jackson? How old are you?
23.
So what plans for the future do you have? What? Why?
I gotta get it renewed. That's all. I just gotta get it renewed.
You have the ability to make it's just a boatload of money with that license, and I don't understand why you're gonna let it expire. I'm making it a condition that you get a job. You need to get a full-time job. You know that, have you ever like explored underwater welding? Have you ever looked into that? How much money do they make? No. How much money do they make? How much is that a year? That's probably like 120, 130 a year. You can make sick money. And come on, man, be better. All right. So do you mind giving me the application? I'm telling you, I'm gonna stay on top of it to make sure that you get that thing back and that you're working, that you're making some good money. Do you understand? All right, come on.
I need to sort of my
Good morning, Mr. Pickney. Sir, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 9th, 2025, the officer observed the defendant's vehicle traveling at the 7600 block of North Wayside Drive with the defective front headlight not illuminated. The traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The defendant provided a Texas driver's license, but was unable to provide proof of financial responsibility. The officer found the Texas driver's license to be not eligible with an active SR suspension, and the defendant was the registered owner of the vehicle, and the insurance database showed insurance policy for the vehicle had expired as of March 14th, 2024.
Got it. All right, Mr. Pickney, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to drive. You will be signing an affidavit with me today promising me you're not going to drive. This is a legal document that you're going to swear to me. If you violate this, I can have a hearing. If you prove it to me that you're driving, I can have a hearing to hold you in contempt and hit you with up to 6 months in jail every single time. Do you understand? So if you drive 5 times, I can have 5 different hearings. Do you understand? Yes or no? Do not drive. If you want to, go get your license, get insurance, come back to me, and I will so happily take this off, but just don't until you do that. It's not hard. You understand? Bless you. Did you want to apply for an appointed lawyer? You know, I had someone send me an email not too long ago where they were in an accident and created $50,000 worth of $50,000 worth of damage to another person, and they didn't know what to do because they ended up just getting sued. Person filed a lawsuit against them, is coming after them. They're, what do I do? What do I do? This is solved by having car insurance. When you're in an accident, that's why we have insurance. So it's not a joke. You look at me like it's, but I'm being serious. I'm trying to help you. Don't, right. Do it the right way. Great things will happen for you. I'm going to give you a lawyer. The lawyer can try to help you out with what you need to do to get your license back. But there's no excuse. If you get into a car, I'm going to lose it. Do you understand? Okay, come on. You are Victor Sanchez.
Yes, sir.
Mr. Sanchez, you're charged with driving on a suspended license. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 11th, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. The officer made contact with the defendant, who was upset due to being in a motor vehicle crash. The defendant stated he did not have a license or insurance and that his insurance was suspended. The officer identified the defendant through NCIC and found the driver's license suspended.
So they didn't catch him driving?
No, he made the statement that he was involved in a crash and that he further admitted he didn't have a license or insurance after, and he said.
I don't know. I mean, what happened? Did an officer really just go to his house and just start questioning him?
So he was originally dispatched to a disturbance and then he did initially just start questioning him. And that's when the defendant was upset and stated it was due to being in a vehicle crash. So the officer wrote that, and the conclusion is that he was driving based on that statement, that he was involved in a crash.
Take a seat for me in the jury box. So, Mr. Duran, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Okay. On January 11th, 2025, the officer was on patrol and observed an odor of marijuana and a male to be smoking in a vehicle nearby at the 8700 block of Lazy Brook Lane. The officer activated emergency lights, positioned himself behind the motor vehicle, and made contact with the defendant. The officer had the defendant step out of the vehicle and advised the defendant that he had been observed smoking marijuana. The defendant stated he was smoking marijuana inside the vehicle because he did not want to smoke inside his friend's home. The officer observed a strong odor of marijuana and conducted a PC search of the vehicle. The officer observed small crumble of green leafy substance known to be marijuana based on training and experience at the bottom of the center console, and 0.37 grams of a small marijuana joint in the ashtray in the cup holder. The officer observed an unholstered black Glock laying in plain view on the backseat floor, and the defendant stated the handgun belonged to him.
Mr. Duran, I'm going to find that there's probable cause to go forward with your case. You see if he has a Texas driver license, please.
Don't worry on it.
All right. You're not allowed to drive unless you have a license and liability insurance in your name. Those are conditions of your bond. Do you understand? Those are the only conditions I'm going to put on you. Be careful. Don't do anything stupid. Do not pick up a new case. Otherwise, I'm going to revoke your bond. I'll put you in jail. You understand?
Yes, sir.
You have a lawyer. Listen to him. He'll take care of you. Because you have him, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get a hold of you, you pick up a new case, become a danger to my community, I'm going to revoke your bond, put you in jail. So you understand? All right. So the only thing is just don't get in trouble. Don't drive without a license and insurance. Okay? All right. We will have you just sign the bond conditions, and after that, you'll be free to go. Okay? All right. Thanks.
Thank you, Judge.
Thank you. Good to you too. So can you file that?
The driver license and insurance?
Please.
Yes, Judge.
Was that state bond conviction?
Yes.
I've been informed by pretrial services that enforcement tested positive for marijuana.
Okay.
Thank you. This is first time.
Come up. What happened to the third kid?
Let me.
He hasn't made it back yet.
Okay. So no more.
Yes, sir.
You're not to. I'm going to test you again in 45 to 50 days. If I find that you're using, it's not going to go well for you. If you stop as of right now, in 45 to 50 days, you should test negative. If you keep smoking, it's not going to go well for you. You also need to get back into high school. This is not a good way to start in life. If you need resources, we have it for you.
I don't got my diploma, but I got my certifications to like work at the refineries. So I can't even work.
You need your high school diploma, man. That's what I'm trying to get you to do, you know? And I have free classes for you to be able to do it. And I can give you the paperwork, so it's not going to cost you anything. But at a minimum, if that doesn't work out for you, you need something to fall back on. You know what I mean?
Yes, sir.
All right. We're going to give you that paperwork. I'm going to bring you back. I want to see that you're doing well.
Yes,
all right? Okay, man. No more smoking.
Yes, I understand.
Okay. All right, guys.
God bless you.
He's back.
Court calls the case of people versus Zachary Radcliffe.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the people.
Your Honor, James Thomas, for Ms. Radcliffe.
Okay, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact that I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, The attorney really didn't say anything on his behalf, and the $3 million bond was put into place. And at that point, none
All
of.
right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
Never.
But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yeah, sure.
But the only thing, I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't, if you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on?
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
Set probable cause, I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m. That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or
Yes,
my staff.
I suggest we set an exam date.
It's not gonna happen until discovery is all complete. He's saying discovery's not, I mean, I'm not gonna do it. What I'm gonna do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set them that way. I'm not gonna set it. I'm gonna hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may never come because it's passcode
And
protected.
then I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's gonna happen. So I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I mean, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where.
What subpoenas?
I didn't say that.
Well, is there other notices out there for anything else that you're doing with, other than his?
I hear that there is electronic devices that are password protected that is going to take some time to get into, that he may have the passwords to, but I don't think he's going to give them. So we're just going to have to wait on that. I mean, that's what I'm hearing.
Okay.
Anything else?
No, thank you.
No, sir.
Wonderful. We'll see you on the 30th. Hey, guys, hold it, folks. Hold on a moment. Who's who with, is that everybody? I just want to make sure. So anybody with defense counsel that was here, they've left already? Or they're on their way out? Okay, let them go first. I know I try to alternate, but I probably got it all wrong, folks. I'm sorry, but I just don't want anything. Let them go. And then, folks, if you would be patient, once they've cleared, then those folks can leave. Thank you. Court calls the case, People versus Desiree Badnovich.
Yep, right here.
Okay, hello.
Interrupt you on behalf of Ms. Bogdanovich. Judge, we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have an in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms. Bogdanovich, no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they told me.
I've been sitting in front of the phone for 4 hours waiting for you to call on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay.
tomorrow, 10
Hold
a.m.
on. Maybe he's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
Okay.
Sir, your name?
Emerson Wilson.
All right, what, you're requesting an adjournment?
I'm asking for an adjournment, Your Honor.
And we have a new bond violation report.
Yes, Your Honor, I'm in receipt of that. I don't know if a warrant didn't go out.
Pardon?
A warrant has not gone out on the case.
You want me to issue one?
No, Your Honor.
All right, let's address it then.
Addressing it, he does have an appointment today for a medical marijuana card. The last time I talked to him, it was you can't use until you obtain a potential card and seek that permission from the court. That didn't get done quickly. However, he does have an appointment today. He did provide me proof. We're working on negotiating a potential resolution in this case. He understands and can direct to the court that he will not use until.
Has he been using? I mean, and so before you answer, understand, I don't want to call over and get levels, but I will.
Speaking with him, and he's willing to tell the court today as well, is yes, Your Honor. He's been defying the court order. He thought that him obtaining a card was enough for starting that process. But he understands now and will not be using. And I think if we go out to the 30th, the levels will be going down until he gets permission from the court.
Probable cause conference will be adjourned to January 16th, 2025, 9 a.m. This time defendant's bond is revoked, defendant's remanded.
Judge, my client did want me to address one issue regarding bond, if you don't mind.
Go ahead.
Thank you, Judge. I explained to my client the statutory requirements for a child support case and his bond. He wanted to make sure that his bond, to ask the court to set this bond to the lowest possible amount. I told him I thought it might be there already, but he wanted me to confirm that with the court. And if not, he wanted to have it reduced to the lowest possible amount.
His bond is set at $3,476, which would mean that he would have approximately owed somewhere in the neighborhood of, I don't know what his current obligation is.
I can let you, Your Honor. I can explain that. His current obligation right now is $15,370.58. That's as of January 6th. He has an ongoing support obligation also of $203. The defendant hasn't made a payment since August of 2023. Technically, the bond should be a little bit higher. It should be about $3,800 right now. But
Right.
but I'm not going to make an issue out of that. So
it is the lowest possible. Thank you, Judge.
Well, it's lower than the
It's
lowest
lower than-
possible.
So it's not.
Do you want me to change it?
Not at all, Judge.
Okay, then we're done with that conversation?
We are, Judge.
We are.
Thank you.
All right, bond will continue. Thank you.
thank you, Your Honor.
The other thing is that I won't address it today, but he may need to appear in person because I've got a violation report from Community Corrections regarding missed samples, 3 consecutive ones.
I actually had a hard time getting to these appointments.
Sir, you might want to talk to your attorney before you start addressing me on that.
Okay.
Positive for THC.
Yes, there was a positive for THC back on December 18th and then 3 successive misses. And prior to that, there was an unable or refused. So here's what I will do. Sir, you're going to need to arrange to be at the courthouse. We will try to get what information we can to you, counsel, so that you can contact him. But I'll adjourn this out just 1 week to the 16th.
I have a court date on that day.
Pardon?
I have a court date on the 16th at 9:30.
Where?
I'm pretty sure it's going to be at 14-2.
14-2?
Yeah.
Okay,
Yes,
we're
Your
right down
Honor.
the
I also
we're right
have
down the
a-
street.
Your Honor, I also have 2 other matters that morning. Would it be possible to adjourn 2 weeks?
Well, I think that I need to address his bond violations. Otherwise, I'll just revoke his bond. We'll come get him and then we'll set it whenever everybody can be here. Which way do we want to do this?
Well, I understand, Your Honor. We will make arrangements to be there. I'll talk to your court clerk about. coordinating.
Fantastic.
Judge. And I
Probable
do
cause.
have Mr. Tournier's phone number from the chat. So Mr. Tournier, I'll be calling you when we hang up here.
Okay.
January 16th, 2025, 9 a.m. Bond
Thank
at this
you.
time. Bond at this time is continued. Thank you. Court calls case of the people versus Kyle Rainey.
Special one for people. Assistant Public Defender, Really, Your Honor, on behalf of Mr. Cal Rainey, who is approaching.
That's what I was looking for. Why? Okay. Go ahead.
Your Honor, today is the date and time set for probable cause conference in this matter. I know the court would want to first address Mr. Rainey's bond violation.
Yes.
I know. So, Your Honor, Mr. Rainey was released from custody. I don't have the date in front of me. However, upon his release, Your Honor, he
left the state.
He did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing.
Yeah, yes, yeah.
To our community.
No, not serious.
Okay. He is, Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to
I
go.
ended up getting in Litchfield one day.
Okay. He indicated that he was
You
only
need to take
in.
your hands out of your pockets.
He indicates that he was only in Indiana for 1 day. He has been back now.
1 day too long.
1 day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield.
Litchfield, Michigan, where I'm from.
In Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously. We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved first. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
No, he knew then.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact, and I apologize.
No, you didn't contact everybody you could have contacted. And you didn't get a response. Any response from the people?
The concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else, he was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not, but the issue is he was on bond for a CCW at the time of this possession case. He leaves the state. And I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And there are, clearly had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was gonna file the bond conditions that were set by this court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she forwarded the testing results to Community Correction. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's orders. It's really simple. Anything else?
Like I said, I got a place here.
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time, the defendants remanded on the warrant. Community corrections for violation of his bond.
Thank you, Your Honor.
Colleen Lowe versus Ronald Henderson, also known as Ron Henderson, file 24019520R. No. Have a seat at the table there. Mr. Forrester, your appearance.
Good afternoon, Your Honor. My name is Jeff Forrester. I'm here on behalf of Colleen Lowe.
Ms. Lowe, your name?
Colleen Michelle Lowe.
Mr. Henderson?
Ronald Henderson, yeah.
Counsel?
Edith Wellenbrecht on behalf of the defendant, Mr. Ronald Henderson.
All right. I don't want to embarrass you. You come in here again with jeans on, Mr. Forrester. I'm going to send you home. Cold or not cold?
I understand, Your Honor.
Today's the date scheduled for trial. Any preliminary matters that need to be brought up? Mr. Forrester?
No preliminary matters, Your Honor.
Ms. Willenbrecht?
No.
All right. Do you wish to give an opening, sir? Opening statement?
Yes.
You can proceed.
Well, on April 17th, the contract was entered into by the plaintiff and defendant. And it was for work to be done on a rental property. And it was quite a long list of work that was to be done. It was divided into 3 separate payments. And those payments were, the first payment was made of that. Work wasn't completed. And this is something that we should have wrapped up in small claims court. But it's, we're here today as a result of the unfinished work. And we're here to show that and prove that.
All right. Ms. Willenbrecht.
Your Honor, the defendant denies all the allegations in the complaint, and we're ready to proceed with trial.
All right. Call your first witness, Mr. Forrester.
I'd like to call Colleen Lowe.
And Judge, I'm sorry, we would like to ask for sequestration of any other witnesses on behalf of the plaintiff.
Do you have any other witnesses in the courtroom, Mr. Forrester?
I do not.
All right. Neither of these individuals in the back are witnesses? Ms. Willenbrecht, are either of them your witnesses?
No, they're not. The defendant has no other witnesses.
All right, sir, you're just observing?
That's correct.
Okay.
Your Honor, I'm sorry. I do have one witness, was Madeline here with us. She actually signed the contract.
This young lady? Okay, ma'am, I'm sorry. You're going to have a seat out in the hall, okay? So I'm ordering the sequestration of the witnesses. I'll ask you to raise your right hand. Solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth so help you God.
I do.
All right, have a seat, please. Have you ever testified before, ma'am?
Pardon me?
Have you ever testified before?
No, sir.
All right. Pull your chair up there. I'd like you to speak into that microphone. I'd like you to keep your voice up nice and loud.
Okay.
You cannot answer with an or an uh-huh.
I don't do that.
Or shaking your head side to side or up and down, okay?
Okay.
All right, Mr. Forrester, you can proceed.
Okay. Ms. Lowe, on April 17th, you're in an agreement with Defendant Ronald Henderson. And it was, like it was in 3 parts, is that correct?
Yes, Madeline actually signed that contract. I was in the hospital.
And it wasn't, but it was in 3 parts.
Yes.
Aware of that.
Ma'am, why don't you hand that to her? Can you identify that document, ma'am?
Yes, sir. This is where he ripped out, actually, I think this is the back door.
that he and his, I don't know if it was his workers or him, but they broke down the back door. They kicked it in because the renter had accidentally locked herself out. So he took off all the moldings and the door was unsecure.
When, did you take that photograph?
I did.
And what day did you take that photograph?
Probably between the 20th and the 28th.
And that is of 2024, correct?
Yes, sir.
Does that photograph accurately depict how the door appeared when you saw it at the time that you took that photograph?
Yes.
You move for the admission, Mr. Forrester?
I do, Your Honor.
Any objection, counsel?
No objection based on the vagueness of the date.
Plaintiff's 1 is admitted. Go on to number 2 unless you have questions about number 1.
You recognize, you get a picture.
That's plaintiff's proposed 2, correct?
Yes.
What does that depict?
That's the door frame that was supposed to go into the back door. That was never replaced.
And you took that photograph?
Yes, sir.
And does that accurately depict the door frame that was supposed to go into the
Yes.
back door? Yes?
Yes.
And you move for admission of plaintiffs 2?
I do, Your Honor.
Any objection?
Yeah, I have voir dire for her.
Go ahead.
Ms. Lowe, did you take that picture?
Yes.
And what date did you take that picture on?
Before the 28th of April. Sometime between the 20th and the 28th. I'm not sure.
Okay.
In that week.
And it was on your camera?
Yes.
And does it have dates?
It just says between the week. It just has April 15th to the 28th.
I thought you just said between the 20th.
The 20th and the 28th. I was in the hospital on the 17th.
Okay.
And what type of camera was it?
The iPhone.
Okay, all right, and, okay. An iPhone, okay. And Judge, I would, based on the new information that this is between April 15th and April 28th, I'm going to object to their admission. Is that the same with the number 1 also? Photograph number 1, would that be
Yes,
also?
well, it wasn't between the 15th because I was in the hospital on the 17th.
Okay.
All right, so answer the questions. Is the plaintiff's proposed exhibit number 1 and 2, were they taken those photographs on the same date?
Yes.
Can you tell me what dates that they were taken on, or what dates, at least in between, that they were taken?
Okay, give me a moment here. I'm sorry, I was wrong. All of these photos were taken on May 6th.
Are you certain of that?
Yes.
So plaintiff's proposed 1 was taken on May 6th?
Yes.
Plaintiff's proposed 2?
Yes.
How about plaintiff's proposed 3 through 10? Do you know when they were taken?
May 6th.
You're certain of that?
I'm certain of that. It's right here.
Any other questions?
May I look at the camera?
Do you have the camera here? Oh, it's your phone?
It's my phone.
Go ahead.
Yes, thank you. Are all the pictures on here? Just.
Yeah. Yes.
Well, it also, that there was changes made to the testimony afterwards.
All right. You want to voir dire on that one too?
Well.
That's
this is
fine.
number
If you,
1.
no, that's fine.
Okay.
You can do that.
And
I'll let you do that.
Okay, thank you.
But you can't, let's not look at the phone anymore unless there's a specific reason for it.
Okay, all right. Would you, okay. I'm going to object to all the pictures based on vagueness.
Why is it vague?
And all the pictures are on a counter. Is that right? Are they all on the counter?
Wait a minute, we're only dealing, hang on, guys, let's slow down. Maybe I'm going too fast. We're only dealing with 2 photos right now. What is your objection? Vagueness?
Yeah, vagueness as to the date.
Well, she's already testified it was May 6th, right?
Yes.
All right, is any other objection?
No.
All right. both of those photographs accurately depict the items that you reference?
Yes, sir.
So plaintiff's proposed exhibit number 1 is the door frame that was, I'm sorry, 2 is the door frame that was supposed to be installed. And door number, plaintiff's proposed number 1 is the broken down, it's depicts the door that he broke when he couldn't get in because the tenant had accidentally locked the door, correct?
Right.
I'll admit plaintiffs 1 and 2. Move on to 3 if you would, unless you have a question about 1 or 2 right now, Mr. Forrester.
I do not.
Okay.
Exhibit 3, you recognize that?
This is the bathroom door where he ripped the frame off the wall. I had asked him to put a new door on, not rip the frame off.
And it was taken when?
May 6th.
Move to, Richard, you're on.
So that was not part of the contract for him to rip that frame off.
No,
You wanted him to install a new door.
yes, just put a new door on.
Any questions of her?
Plaintiff's 4, you recognize this?
Yes, this is the back door with the molding removed, the door frame. I don't know what it's called, the outside of
the door frame?
Yeah.
The door molding, was that door operational?
No. And we could not lock it. We could not secure the house.
And how long was that, how long did that remain in that state? Was it repaired?
It was repaired just recently.
This is January of 25. When was it repaired?
Just about 2 or 3 weeks ago.
And who did the repairs?
Handyman,
And what did that cost you?
$1,150.
I'm sorry, how much?
$1,150.
Was that the only thing that they did for you for that amount?
No, he additionally did other things to repair. He also replaced the bedroom door that had been removed and the frame ripped out.
So I'm sorry, can you repeat that? For $1,150, you're telling me he repaired?
He put in the back door.
Okay.
And he put in the bedroom door that had been ripped out and the molding removed. He additionally put in smoke detectors and repaired the bathroom sink.
And that was in the bedroom door?
Pardon me?
That was in the bedroom door?
Yeah, the bedroom door had also been ripped off or taken out and the molding ripped off. And he repaired that wall because when they ripped it off, they didn't score the wall. They just ripped it off and the plaster came off.
Okay. All right.
Now, plaintiff's exhibit 5, you recognize that?
This is where paint was dripping down the walls. A part of the contract was to paint the entire house inside. And this is paint dripping down the walls.
Which walls?
Living room. There was also paint spilled in the kitchen that I'm going to have to replace the floor because it got into the tiles.
Ma'am, did you take any pictures at the start of the project being done for the contract?
No.
Okay, so, all right. All right, no objection.
Plaintiff 5 is admitted.
Plaintiff 6, you recognize this?
Yes, this is the foundation around the house. He was supposed to tuck point the foundation and then paint it. He painted it without tuck pointing it. And you can see in the photograph that the painter's tape is still left there.
Plaintiff 7. More of the same?
More of the same.
That's the foundation around the house?
Foundation around the house.
That he's supposed to tuck point and paint?
Not completely painted or tuck pointed.
Plaintiff 8. This is an example of paint.
Objection to the explanation that he's giving her.
All right, can you identify plaintiff's eight?
Yes, this is the front
Proposed.
porch.
Front porch?
Front porch, that it remains unpainted. Wyandotte requires you to paint the foundation of your house, and it is not, the painting is not complete.
Okay.
There's 9. You recognize this?
Yes, this is the exterior of the house, the windows that remain uncaulked. They were supposed to be weather tight, caulked and painted, and none of that has been done.
Can you answer, was that part of the first?
Yes, painting. When the first part was for supplies and labor, and the painting was to be completed. And it, to this day, is not completed.
That's number 10.
Plaintiff's 9 is admitted.
This is where they spilled paint on the kitchen floor and it seeped into the boards. It's permanent damage.
When you say into the boards, you mean into the molding?
No, you know how they put those boards together?
Okay.
They're planks for flooring.
Oh, flooring.
Pardon me?
I'm sorry, over pine flooring?
Okay.
It's flooring that it got into the seams of the boards.
I got it. Okay. Any objection on the admission of 10?
No.
Plaintiff's 10 is admitted.
And the framework was part of that painting?
Well, I had no idea he was going to rip the framework out. I just wanted a new door. So that
on the
we could-
bedroom.
Yeah, on the bedroom and on the back door and
that he broke.
and the bathroom.
Well, you didn't anticipate at the time of the contract he was going to rip out the back door, right?
No, we knew that, I knew that he was going to rip out the back doors to replace it, to put that new frame in. But I didn't know they were going to take all the moldings and everything off.
I got
and
it.
to do that to the bedroom and the bathroom.
Right. Okay. Go ahead, Mr. Forrester.
And after roughly, I guess, 2 days, he was on site?
I don't recall how many days he was there.
But then he vacated the work and left some tools there, left some items behind.
Yes, he left paint and a shop vac.
And and you reached out to him at that time?
I did.
And your response?
No response. I tried to text him. I tried to talk to
The
him at my
gentleman that was
job.
doing the work for you, do you see him?
He's right there.
Can you describe what he's wearing?
A gray jacket and a light blue shirt, I think.
And that is Mr. Ronald Henderson?
Yes, it is.
All right, the record should reflect the witnesses identified the defendant. Ask your next question, please.
And did you eventually contact him after this first round of work?
Well, after I filed in small claims court, then he contacted me.
I see.
And at that point, it was a no-go. He had caused enough destruction and it just wasn't going forward at that point.
Did he ask for more money?
Yes,
When was that?
I don't know.
Subsequent to the work that he did?
When he thought the painting was finished, probably within a week or so, he wanted more money, and I was not going to give him any more money after seeing what was done.
How much money did you pay him?
$8,620.
That was a deposit.
Yes,
And the total contract price was,
17,000 something.
was it 17,240?
Okay.
I want you to verify that. I don't want you to.
Can I get the contract?
Well, he can show
Okay.
you the contract.
17,240.
Miss Lowe, you saw the contract, is that right?
I saw the contract and I made additions to it.
Okay, all right. And on that contract, you didn't say anything about whether or not to replace the frame. You just wanted to have a tight door in there. Is that right? In any place of the doors?
The frame was already in the house. And yes, the frame was to go in the back door.
Okay, all right. But as far as how the defendant would put in the door, there's nothing really specific about that. It says.
No, but I didn't expect him to kick it in either.
Did you see him kick it in?
No,
Okay. So somebody told you he kicked it in?
the renter.
Okay. And then did you hear the renter say that her boyfriend kicked it in?
No,
Okay. All right. Did someone tell you that that's what she said, or did she say that to you?
she said that to me.
All right. Now, also in this contract, there's no date that says the doors must be completed by this date.
Actually, yes, the work was supposed to be completed within a week for the city inspection.
Okay, but that's not in the contract, is that right?
No, but I have texts to that.
In the contract?
No, I have texts.
Was there any additions made to the contract that both of you signed?
I don't know what you're asking
Did
me.
you make any changes to the contract that both you and Mr. Henderson signed that said that this painting has to be done in a week?
Not that I'm aware of.
Okay, you didn't sign anything?
No,
Okay. All right, now, but you did understand that you would make a second payment after the painting was done.
yes, but the painting was not done.
I'm not asking about that. You said that about 10 times and I will hear it loud and clear.
Okay,
But there was nothing in the contract that said painting must be done in a week or 2 weeks or 3 weeks.
not that I'm aware of.
Okay. Did you look at the contract at all?
Yes,
Okay. In fact, you made some changes.
yes.
What was her lease up?
No, her lease was not up.
Okay,
She had an open-ended lease.
okay. All right. Now, was Madeline Jones the person that signed this? Was she overseeing any of the work also?
I don't know. She was in the hospital with me.
Okay. Both of you were in the hospital?
No. She wasn't admitted.
Oh, she was watching you as
Yes.
a friend?
Yes.
Is that right? All right. All right, no further questions, Judge. Thank you.
Was she the renter?
No.
No further questions?
No.
Call your first witness.
Judge, I call the defendant, Mr. Ronald Henderson, to the stand.
Okay, you can come on up here, Mr. Henderson, sir.
Mr. Henderson, please state your name for the record.
Yes, Ronald Ray Henderson II.
And how do you know the plaintiff, Miss Colleen Lowe?
I know Miss Colleen Lowe from the neighborhood that we lived in. I go in the gas station a lot. She works at the service station, and I come in all the time, get gas, and she asked me to help her with the work as I was coming in back and forth. So that's how I met Miss Colleen.
Okay, what did she say to you?
She said, young man, I have some work that needs to be done, and I've been trying to get a hold of you. People told me, good things about you. Can you help me with this punch list? I said, Miss Colleen, I'm kind of busy right now, but let me see what I can make happen for you. So I eventually got her address, and I was in the area in Wyandotte at one time, and we met over there, and that's how I looked at the job, came up with an estimate for sending it over, and that's how that got started.
All right. Did the issue of how long this project should take for you to ever come up?
No, man, I told her that it would be almost impossible to get that list done in 2 weeks. I told her that, it's going to take way longer than that because the punch list is real long. Things have been neglected, and I even mentioned that when we was there doing the estimate. I said, man, this stuff haven't been done in a while, it's going to take a minute. So I went to the city of Wyandotte to ask, about the date. And they said that she scheduled the date. And I'm like, you guys didn't schedule the date? And they said, no, she scheduled this day. I said, well, so they said pretty much it was her that wanted it to be done in 2 weeks,
Okay.
not them scheduling the dates for the inspector to come out.
And so are you the person that prepared the contract?
Yes, ma'am, I am.
And did Ms. Lowe make any changes to the contract, or have you any questions about it?
The changes that was made were, I know that Miss Colleen was in the hospital at the time, so she had to sign for Miss Colleen, which I was aware of
Ms.
that.
Jones signed for me.
Miss Jones, Miss Melanie.
Okay.
And so I was okay with that because they always was together. So I figured they was on the same. So, but for us the changes, I don't remember no changes like that.
Okay.
That we specifically talked about. It definitely wasn't the time frame, but we told her we was just going to work hard at it and try to get it done, you know?
Okay.
But then I did let her know that what the inspector said and what the city said, that we can reschedule a date.
Okay.
And I never heard, she never responded. So, yeah.
Okay. Now,
When is the last day that you worked at that project? Can you tell me?
Yes, sir. Give me 1 second, Your Honor. Can I look through my texts?
Sure.
Okay.
That will refresh your recollection.
Yes, sir. It was around the week of May the 4th, Your Honor.
You remember what day you started the actual job?
Yes, sir. I can let you know that. I think it was start of the contract, Your Honor, was April 16th.
So that's the day the contract was executed. Is that the day you actually went in there and started working?
Yes, sir. That's the day we started getting everything, the materials and stuff together to get the
Did you
job.
have all the painting done on by May the 4th?
No, sir. All the painting wasn't complete because of not being able to get inside of the house at times. So it was a little bit of painting left. We did 2,500 square feet of painting of ceilings, walls in the basement. The ceiling in the basement, the walls in the basement.
Did you have another job that you were performing at the time of this one?
Electrical jobs, but nothing to do with that will pull us away from this job. Yeah.
How many times could you not gain access to the property?
About 4 times, Your Honor.
Did you?
Oh, yeah. Knocked, called. I even had the tenant's phone number.
Let me finish.
Yes, sir.
She said that you broke down the back door.
Your Honor, that's not true, Your Honor.
Who did that? Do you know?
The tenant's boyfriend kicked in the door. She told me and the workers all about it. And they even have a police report at the Wyandotte Police.
Who told you that?
The tenant. Her boyfriend kicked in the door. Like, we never kicked in the door. So what happened, Your Honor? One day, the tenant locked her keys in the house, and they asked us to get in the house. So one of my workers, because the door is already framed, was already like busted, took a screwdriver and was able to get in for it. We never kicked the door in. And, you know, I was trying to get a hold of the tenant. So
Do you have any text messages?
Yes, sir. Yes, sir.
Hang on.
Yes, sir.
Just listen to my question.
Yes, sir.
Do you have any text messages or evidence that you called her? And I'm talking about Ms. Lowe on or around the 4th and advised her that you could not get into the property?
Not Ms. Lowe, Your Honor, because due to her being in the hospital, didn't want to bother Ms. Lowe with a lot because she was in there for congestive heart failure and didn't want no stress on her. So it was between me and the tenant and like to get the things done. So I do have, you know, proof that me and the tenant talked. And she apologized to me on text message saying that she was asleep or she wasn't feeling good or please don't come today. I have all those messages. If you'd like to see them too, Your Honor, between me and the tenant.
On or about May the 4th?
Yes, sir.
And are you saying, though, that you could not get back into the property because the door was locked on and after May the 4th?
Periodically, yes, sir, Your Honor.
Well, you said the last day you worked was May the 4th, right?
Well, somewhere in the week of May the 4th, I said, Your Honor.
Okay. Whenever you last went there on the week during the week of May the 4th of 24.
Okay.
Whatever day you last went there, did you stop going because she had not given you the second payment? Or did you stop going because you had other work?
Oh, no, sir. I stopped because of the second payment, Your Honor. And then I did communicate.
The second payment?
Yes, sir. I communicated.
But this says the painting was not complete. This says the second payment's due after the painting is complete, right?
Okay, so the painting.
Yes or no?
Yes.
And did you not say that the painting was not complete?
Well, it was.
Yeah, true or false?
True.
Okay.
True.
And you're putting that on the tenant because the tenant was not letting you in.
Yes, sir, Your Honor. And there was a lot of confusion, a lot of chaos going on.
Okay. Okay. Go ahead.
Can I give you one more? So the reason the second payment was talked about was because the doors was on the second phase. And installing the doors.
You didn't need to get into the interior of the house to do the painting and tuck pointing to the foundation,
The
correct?
tuck point was on the second phase.
I'm just asking you a question.
Well, I didn't finish getting my statement. The tuck pointing was on the second phase and the doors were installed, was supposed to be on the second phase. She kept pushing about the doors being on. I said, well, ma'am, that's the second phase. So that's how that came about, George.
But you could have done the tuck pointing and the painting to the foundation on days when you did not have access to the interior of the home. Is that true or false?
It's true, but we had a lot of other outside work we had to do as well, Your Honor. We had to seal the complete house. They had holes all the way down the house. I have pictures show you where water was running down the house. We sealed the whole house. So we did plenty of the work those days that we couldn't get access. So to make, I got pictures and everything to prove it.
I'm not quarreling with you, but you did say that the painting was not complete, right?
No, it wasn't complete.
And you said that you were not owed the second installment until the painting was complete, right?
Yes, sir, Your Honor.
And the painting was not complete to the foundation area where you had to do tuck pointing and painting, correct?
Correct.
And to perform that work, you didn't need to go into the interior of the house, did you?
To tuck point, no.
Or to paint the foundation.
No. And so the painting of the foundation did start, Your Honor. It just hadn't been finished all the way. Complete. Because of the tuck point.
Yeah.
All right, now, what had to be completed before you could ask for the second payment?
So the painting needed to be completed. And the only reason the second payment came up was because she was pushing about the doors. Get the doors on, get the doors. I said, well, ma'am, Miss Colleen, the doors are on the second phase. You want the doors, you got to pay us another payment to get the doors installed. So that's the only reason that came up about the second payment is because she wanted to keep pushing about the doors. I'm like, ma'am, the doors are getting installed once the second payment is released. That's the second phase of everything. And I tried to explain that like several times, but.
Sir, you wrote the contract.
I wrote the contract.
You were the one who said the second installment wasn't due until the painting was complete, correct?
Exactly.
You couldn't paint the frame area and the doors until the doors were installed, correct?
I couldn't paint. Say that again, Your Honor. I couldn't paint the door.
You had some painting to do on the door frames, correct?
No, because the door frames come as one. We paint them and they already painted. We put the whole jam in, Your Honor.
But you still had some painting to do when you put the door in, correct? Or not?
I never put the door in. That never was installed.
But you would have had to do some painting once you put the door in, true or false?
True.
Okay. That painting wasn't done either, right? Because you never installed the doors, right?
We never got to installing the doors, right?
And you're saying that's because the tenant kept locking the door, or didn't that have anything to do?
I didn't answer the door.
I'm trying to make sure I understand. Are you saying the doors were not installed because the tenant wasn't around to let you in?
The doors wasn't installed because it wasn't on the second phase, Your Honor.
All right. So the painting, then you agree the second payment couldn't possibly be due. Could not possibly be due until at least the second phase was done. True?
True. But the way we do it.
So then the second installment payment wasn't due yet.
But she kept pushing about the doors. And that's what I told her. If you want the doors right away, we got to get the second installment payment.
All right, go ahead.
All right, besides the doors, was the painting done, or was there more painting that had to be done?
It was painting that had to be done because the basement was full and we had to move stuff from one side of the basement to the other. So it was like a little closet room in the basement that you really couldn't even tell was a door. And there was a room, I guess, like that wasn't painted back in there. That's a little like the utility area. But that wasn't completed in the back.
Was that the only thing as far as painting and the doors situation that you discussed with the judge?
No, man, we would have to like, the tuck pointing that after the tuck pointing was done, we was gonna have to repaint those areas that needed to be tuck pointed.
All right. So at the time that you asked for the second payment, you had a little bit of painting left to do.
Mhm.
But the other signers of the people that were parties to the contract wanted you to start doing the doors.
Yes, ma'am, Your Honor. Yes, ma'am.
All right. And why didn't you just tell her, why don't I just finish the painting and then I'll start the doors?
I tried to, and I tried to communicate that, and she would not hear me for anything. I even have text messages to prove that I was trying to communicate that to her.
Where are they?
Right here.
What did she say? What did you say?
So she sent me a text saying that the painting.
Read it exactly out loud.
The painting is not finished.
What day was that?
This was on May the 7th.
Okay. What else does it say?
That's it, Your Honor. She
just said the painting is not finished. She just blurted out the painting is not finished on May 7th.
Yep, that's what I'm reading.
Well, did you make some comment by way of text that caused her to say the painting is not finished? Did you ask for the second installment on May 7th, Mr. Henderson?
I don't have any record of that, Your Honor.
Well, let me see the text. Let's just make this easy. You just read one text and it just says the painting is not finished is what your testimony is, right? Yep. Let me see it. But before that, on April 27th, you said, hey, Ms. Colleen, I'm in the middle of getting work done today. We're working today, tomorrow, and the rest of next week. So we'll talk Monday. I have to focus on the work. We will be done. We will discuss the contract Monday. For now, I have to work, so we will talk soon. Thanks. I got to stay focused today. And she said, you need to call me. Right?
Yep.
And then she said, the painting is not finished, right?
Right.
And then you said, we are ready on May 8th. You said, we're ready to finish so we can move to the next phase. Okay. Right?
Right.
She said, I've called you multiple times with no answer on June 4th, right?
Your Honor, I've seen her at a job.
I'm just asking you, is that not what she said?
That's what the text message said. I'm not there.
Okay. But she didn't just blurt it out. The painting is not.
That date, that's what I read.
All right, go ahead.
When you spoke to her.
So you gotta take that phone out of here real quick, phone.
Yeah, you're gonna have to take it out of
Take it out
here.
of here.
So your last text was around, it was in May. Now, when you.
That's not true, is it, sir?
The last text would have been, let me get the exact date for you, Miss Peter. Around June 19th was the last text.
Okay.
And you hadn't been over there since May the 4th.
Yeah, because the tenant wouldn't let us in.
Okay.
Due to Miss Colleen and them instructions.
Okay.
All right. Would there have been a problem if you could go back
Oh, no,
after May 4th?
No, ma'am. I even have text messages here letting her know that we were prepared to go and finish.
Find it.
Just read it, Your Honor.
What? Did you?
On May the 8th, I said, we are ready to finish so we can move to the next phase.
Did you reference anything about the tenant not letting you in?
No, I didn't.
Did you reference anything to her about how she had to enable you to gain access to the property?
No, me and Miss Colleen.
I'm just asking you that question.
No, we didn't.
Go on to your question, Ms. Elmquist.
All right. So, so after, your last day, did And you said we're ready to go on May 8th. You just said that.
Mhm.
Did Miss Lowe or Miss Jones respond to those texts and said you can come in, that we're ready for you or anything to indicate?
No response.
Why didn't you just go on your own?
So every time we would show up, the tenant wouldn't answer the door, and her kid was there at the home by herself at times, and we're not going to enter the house with a underage minor being there. So it was just a whole lot of things going on in the situation.
Did Miss Lowe realize that there was a tenant not letting you in?
I can't say she did, but she kept in contact with the tenant, so the tenant had to let her know.
Did you ever tell her the tenant won't let me in?
Oh, I told her the times that we was locked up, Your Honor.
Well, that was prior to May 4th? Or May 8th, prior to May 8th?
It was all during the times. It was periodically throughout the whole process.
Right.
Yes, ma'am.
But then after May 8th, that was it? Did you ever go back and try to get in or talk to Ms. Lowe about restarting up the project after that?
Let me see, on May 8th, I did tell her let's start the project. Yes, ma'am. And I seen her at the gas station that I met her at because we both live in the same area.
Yeah.
I said,
So what did you say to her at the gas station?
I said, hey, Miss Colleen, I've been trying to get a hold of you because I had made several attempts to reach out to her on the phone and reach out to her and let her know, like, look, we're ready to complete and finish. And she said, please don't do this at my job. And I was like, okay, Miss Colleen, I'm not trying to make a big fuss of it. I'm just letting you know, been trying to get a hold of you so we can complete the work and we can move on. And so the reason behind it, the tenant, and may I say this, the tenant said that she wanted to get her out of the house. And so that's why she made the timeline so tight to try to have the work done so we would fail the inspection so she can kick the tenant out. So we was,
is that what somebody told you or is that what yours?
no, this is what the tenant told me.
Okay.
And so when I went to the city to verify, well, can we move this date? Because 2 weeks is not enough time to get this punch list done. They said, well, Miss Colleen is the one that set the date.
We heard that. You're right.
And so I'm like, well, can't she just have you guys re-come out? They said, well, she can reschedule, give you guys more time. I let Miss Colleen know this. And Miss Colleen never got back with me about it.
What percentage of the work do you think you completed?
For the phase one, Your Honor, I would say at least 3/4 of the work, Your Honor.
So 3/4, so there's 3 phases.
Yes, sir.
So phase one, you think you got 3/4 of the work done?
Yes, sir, Your Honor.
And then none of phase 2 or 3, is that true?
No, phase 2 and no 3. No, sir, Your Honor.
So you think roughly, I don't want to put words in your mouth.
Okay.
I want to go back here for a second. You're telling me you didn't do any in phase 3 and didn't do any in phase 2, right? But you did all but a third of phase 1?
Well, a quarter, Your Honor.
You did a quarter of phase 1?
You say all but a quarter of phase 1.
Okay, so you did 3/4 of phase 1 and none of phase 2 and 3.
Well, I think we did some of the items that was on phase 2 or 3.
What did you do on phase 2?
There was some plumbing, it's a plumbing pipe that's outside, repair the front fence. It needed to be done.
What percentage of the work in phase 2 did you do?
Can I look at the contract? The number 1 was completed.
What, we'll fix the front gate on the
yes, sir.
Property?
Number 4 on first page is done.
Which one was that? Read it to me.
We will cut the metal pipe sticking out of the ground in the backyard.
Wait a minute.
Up against the house.
Wait a minute.
It's right down here, Your Honor. Second page.
Okay, so they're numbered out of order is why I'm asking. Okay, so number 4, we will cut metal pipe sticking out of the ground in the backyard.
Yes,
right?
sir. Yes, sir.
You did that?
Yes, sir. And capped it for the code. It's a number 9 right up under that one. It says all windows will be recaulked and weather tight. Also caulking around the outside of the house.
You did all of that?
Yes, sir, and I have pictures to show you that.
Okay.
There are 12, next page, Your Honor, it says page 5, look like, 3. I can tell it's kind of cut off, 3, look like. There are 12 stress cracks in the house that have to be fixed. INT will fix them and paint the area. But the client said, we agreed on white paint. That's number 1 was done.
Did you do all of that work?
Yes, sir, we did fix the stress cracks.
Did you paint the area where they were at?
Yes, sir, we did, Your Honor.
Okay.
Number 17, Your Honor, INT will paint basement walls, ceilings, color to be picked by client. We picked black for the ceiling.
Hang on. Did you paint all the basement walls?
Yes, sir, all the walls.
And the ceiling?
Except that one utility room that I was telling you about that was hiding off in the color. There's one of those photos that's available there.
And so you painted the walls, all the basement walls.
And the ceiling, Your Honor. Complete ceiling.
And the ceiling, okay. Except the utility room.
Yes, sir.
So is that correct now? You're still sticking with, you did about 75% of phase 1 and none of phase 2 and 3, or is that incorrect now?
Well, yeah, Your Honor, I'm sticking with that because that's what we was going to do, the painting and the outside ceiling.
I just want to be clarified because I don't want to put words in your mouth.
The ceiling built outside.
You're saying you did 75% of phase 1 and none of phase 2 or 3.
The only part of phase 2 that we did do were the demo.
Hang on.
Okay. The demolition of.
What part of phase 2 did you do?
We demoed the front rails that needed to be replaced. We demoed the doors that needed to be replaced. Removed.
So what percentage of phase 2 do you think you did, which would include removing the materials and the doors that needed to be replaced? And you said some of that was phase 2.
Well, like the fixing of the fence and the cutting the pipes and then start to go pull. We was getting ready to go pull electrical permits.
I'm just asking you what percentage of that phase 2 that you think you did.
Not much, Your Honor.
Okay.
Not much.
So not much?
Not much of phase 2.
Okay. All right, go ahead, counsel.
Sir, you gotta get your phone and take it out of here, please. Leave it out of the courtroom.
Sir, please.
I thought it was on. Well, make sure it's off this time. Leave it out of the courtroom, sir.
Yes, ma'am.
Is there anything else that you want to say about the work that you did for the contract?
Yes, Your Honor. We was just trying to help get the punch list done. I did mention to her that we could reschedule the time to get, more time available because I talked to the city worker and I went down to the city myself, talked to her. She said all Ms. Lowe had to do was call in, reschedule the date. And Ms. Lowe.
Is this because you had to go on another job?
No, sir, Your Honor.
Is this because the tenant wasn't letting you in?
Well, this was because of all the confusion that was going on throughout the time. Your Honor, not being able to get in, having to move the tenant stuff, like having to, she was sick. Please, she'll text me one day, please don't come today. Like it was so much going on. It was not enough adequate time for me to get that work done in those weeks. So that's why I went to the city, Your Honor.
Okay.
And talked to him myself, say, hey, look, is there any way you can give her more time? And they said, well, she's the one makes the schedule.
I see. You told me that a couple of times. I get it. I understand. Okay, fair enough.
No further questions.
Do you have any crossing, Mr.?
I do, Your Honor.
Well, what did you do with the well prep that? I mean, I could have done a better job than this. I'm looking at this paint dripping.
Well, you haven't seen the walls, Your Honor. This picture don't do the house justice of how this house looks.
Was that primer or was that regular paint that you were going to leave on the wall?
This don't even look like it's been painted. Like this is a horrible picture because the house never looked like this. Like the finished product. You see this, Your Honor?
See what?
Like this right here, this is not how we left the paint job.
That's not how you left the paint job, but you painted it?
Well, I don't see where, those pictures are not showing me exactly where this is at, but I can clearly tell this is old paint.
You have argument?
Well, yeah. Yep. Bottom line of this, Your Honor, was, this was an $8,000 or $8,500 contract, roughly, approximately. The work that was done, was,
Well, $17,240, right?
the contract was this particular first.
She paid $86.20.
Yes, correct.
Okay.
Yeah. Yeah, this first phase was as we heard, there was a lot of confusion. Apparently, there was a lot of things going on, but the bottom line was it was the contractor's obligation to make it known that he was unable to get in the house if that was the case, and the quality of the work and the cost and the fact that the first part wasn't even done, wasn't even complete, and he was asking for more money. It's a pretty simple case, Your Honor.
How much are you asking for?
We were asking for the 1 second here.
Well, I saw your trial brief.
Yeah, the trial brief didn't include that latest to fill to replacing the doors that were ripped out. So we're asking for a total of $12,430.
I'm sorry?
$12,430. The original $8,620 plus the 3 months of lost rent from the renter.
But I didn't hear any testimony on that. None. Go ahead.
And the additional amount that we already discussed for the $1,150 to fix the doors.
Okay. Good enough. Argument?
Your Honor, I agree with plaintiff's counsel, Mr. Forrester, here to some extent that there was a lot of confusion. We had clients who were in the hospital, couldn't sign a contract, read a contract. We have a house that was over 20 years old that Mr. Henderson was trying to repair to the best of his ability. We have pictures that are very, very delineated in certain areas. And Mr. Henderson testified that he had completed at least 75% of the main job. And then at that point, when for some reason, the 2 weeks area came in and it was all blamed on the Wyandotte people having to have it done. It really didn't have to be done. And so so we have a man here who said what he completed. We don't have pictures of that, of what he completed. We have pictures of other things that should have been done probably in phase 2, and everybody agreed that he would get paid in phases. And based on the testimony of both parties, it sounds like to me that Mr. Henderson is entitled to his first payment. And we would ask that would settle the case. Thank you.
Thank you. Parties entered into a contract. And the total job cost was to be $17,240. There were 3 payments scheduled. Plaintiff paid the defendant $8,620 initially at the time of the signing of the contract. Second payment was due after the paint was complete. And the third payment after the job complete. I'm not persuaded in the least that the plaintiff breached the contract in any form or fashion. Even if I was going to take the paintwork that was shoddily done, shoddily completed in a way that a teenager wouldn't complete it, and I'm dead serious about that, Mr. Henderson. I'm referencing this photograph, plaintiff's father. Even if I were to count it as being partial performance, and I can't because it's unworkmanlike, there is no way that the painting was completed. I mean, I don't even have to reiterate the testimony here. You didn't put in the doors. You didn't paint the doors. You didn't tuck point outside. the foundation and you didn't paint that, and you can say that's part of project two. Well, there's no way in the world Ms. Lowe breached this contract by not making a second payment. You said, now listen, it's my turn to talk. I'm telling you why I'm going to do what I'm doing. You said to me that all but 25% of phase one was completed. I don't believe you. I don't believe hardly any of your testimony. This theory that you've concocted, that somehow you were unable to perform the work because the tenant didn't let you in, I find to be totally incredible. I don't believe a word about it. You didn't do workmanlike contractual work. These pictures clearly show that. This painting is a disgrace. I don't believe hardly any of your testimony, sir. And don't, it's not your turn to talk. You can appeal this all you want. Take it up the circuit, then court of, take it wherever you can take it. Ms. Lowe did nothing wrong here, except she hired somebody that didn't do the work he was supposed to do. Period. The only reason I'm not giving them the rental amount is because they didn't admit any testimony with regard to rental loss as a result of this work. I'm going to find that you only completed at best 10%. Stop. Sir. Hey, listen, don't get smart with me while I'm rendering an opinion. You can go out in the hallway and tell whoever you want that I'm a horrible judge. Go out in the parking lot. I could care less, but you're not going to interrupt me while I'm telling you why I'm doing what I'm doing. You yourself said you didn't do 25% of it, of phase one. And the contract was for $17,240. I don't think you hardly did any work in a workmanlike manner. Therefore, I am taking off a mere total of $1,200 off of the $8,600, which should leave you with $7,420. She also had to pay work that was supposed to be performed to the tune of $1,150. Your total here, the total judgment amount is for $8,570 plus statutory attorney's fees, plus filing and service fees. Judgment for plaintiff. I don't find you credible. I just can't believe some of the things that I was hearing here when I was asking you questions. I don't know if you think that I'm not a very wise man, and that's okay. That's your opinion. But you talk to me sometimes, or at least you did today, like I don't know that 7 and 8 is 15 without a calculator. Don't do it again, I'm telling you. Take your exhibits back, counsel, 1 through 11. That's the judgment of the court, and you can keep those. I'm sorry, that's mine. That's mine. Oh, wait a minute. This is 11. You can prepare a judgment and send it in. That's for $74.20 plus the $11.50 for $85.70 plus filing fee and service fee. You can submit that under the 7-day rule. Court's in recess. Stay seated, everybody.